Hello and welcome to the wonderful world of copyright law. The aim of this video is to explain the meaning of the right to communicate to the public in the context of Australian copyright law and to explore how this particular right may be infringed. It is firstly important to understand that copyright owners are protected by the Copyright Act 1968, which provides copyright owners with certain rights. These rights allow copyright owners to control protected works or subject matters in a number of different ways, including the right to control how, if, or when the work can be communicated to the public. It is also important to understand that this exclusive right to communicate work to the public applies to many types of potentially protected copyright material, including literary, dramatic, or musical work, artistic work, sound recordings, films, and broadcasts. Now, in order to understand how this right operates, it is essential to break it down into two main components: the meaning of communicate and the meaning of to the public. The meaning of communicate is actually defined in Section 10 of the Copyright Act itself as to make available online or electronically transmit a work or subject matter. This definition clearly articulates that the right is focused on electronic or digital communication via the internet, through email, etc. It is important to understand this limited scope and narrow definition of communicate. For example, communicate for the purposes of this right will not include the communication of hard copies of musical work, artistical work, or films. The words to the public are also defined in Section 10 of the Copyright Act. The phrase is defined as meaning to include the public within or outside of Australia. As such, material that might be directed to an overseas audience will be included under the scope of this right. In the New South Wales case of Woolworths and Olsen, Justice Einstein built upon this meaning further and held that whether a communication is made to the public is very much a matter of fact and degree, requiring the court to consider the identity and purpose of the sender, the general accessibility and intended audience of the communication, and the identity of the recipient. Justice Kirby in Telstra Corporation and Australasian Performing Rights Association also developed three principles to consider when dealing with the meaning of to the public. Justice Kirby held that 1. A communication can be to the public notwithstanding that it is received in private and domestic circumstances. In the 1940 case of Mallow and Australian Broadcasting Commission, a radio program broadcast on the airwaves at large but received in individual households was held to be a broadcast to the public. This case was decided before the current meaning of communicate was developed, so a new age example of this principle would be, say, putting copyrighted work out onto the internet, which is then received privately. Justice Kirby also held that a communication is more likely to have been to the public when it occurred as part of a commercial activity, such that it inflicted economic harm on the copyright owner. For example, with a musical work, the right to communicate to the public will more likely to have been infringed if such a work could have been sold to the benefit of the copyright owner. Lastly, Kirby held that a communication is more likely to be made to the public when that communication was to the copyright owner's public, being the group which the copyright owner would otherwise contemplate as its public for the performance of its work. So when using the musical example from before, if a copyrighted musical work was communicated to a group of musical critics, it is more likely that this will be construed as an infringement, as it has been made to a group which can be considered well within the copyright owner's public. So, in conclusion, the right to communicate a work to the public will be infringed when A. The copyrighted work has been made available online or electronically transmitted, and B. This communication was made to the public, taking into account factors such as the identity and purpose of the sender, the intended audience, whether or not this communication will be likely to inflict economic harm on the copyright owner, and whether or not the communication was made to the copyright owner's public.
Created using Powtoon.